On Contact with Chris Hedges. Our courts and law schools have become wholly owned subsidiaries of the corporate state. They have abandoned the guiding principles of justice. The judiciary and legal profession serve the needs of the 1%, not the 99%. The rule of law has been inverted. It does not guard against the abuse of power, but advances the interests of those with money, power, and influence. Our elected officials, as Ralph Nader has pointed out, have permitted the creation of a judicial system with secret law, secret courts, secret evidence, secret budgets, and secret prisons, all put in place in the name of national security. Attorney-client privilege has been abolished, and redacted, published judicial decisions are released to the public. Habeas corpus, probable cause, privacy, and due process have been, for many, erased, especially for the 2.3 million people railroaded into our prison system without trial. RT correspondent Anya Parampel examines the collapse of the American judicial system.
Do you have faith the justice system is there to serve you? The ballooning private prison industry wouldn't be possible without courts enthusiastically sentencing nonviolent offenders to time behind bars. And thanks to regulations like the federal 3 strikes provision instituted by President Clinton in 1994, that dynamic has been officially codified. Let's look at the state of California as an example. Bipartisan policy advisor, the Legislative Analysis Office in California, analyzed the impact 10 years of 3 strikes had on the state and found the majority of inmates imprisoned under 3 strikes were serving for nonviolent or non-serious crimes. The high rates of sentencing led to serious overcrowding. By 2011, the catastrophe boiled over, with some prisons reaching 300% capacity. To remedy this situation, the state began paroling non-serious offenders. Criminology professor Jody Sunt investigated whether or not the policy impacted public safety and told the Washington Post in 2016 an astounding 17% reduction in the size of California prison population had no effect on aggregate rates of violent or property crime. But the private prison industry in the state still thrives, with private prison company Correction Corporations of America still managing to double its revenue in California from 2008 to 2012. This is the result of the way our judicial system is designed. As U.S. District Judge Jed Rakoff stated in the New York Review of Books in 2014, our criminal justice system is almost exclusively a system of plea bargaining, negotiated behind closed doors and with no judicial oversight. The outcome is very largely determined by the prosecutor alone. Considering this, perhaps it's unsurprising that in 2013, 97% of federal criminal cases ended in a plea deal. That may have something to do with the fact 90% of criminal defendants qualify as indignant, leaving them dependent on underfunded and overworked public defenders. This data begs the question, is our judicial system designed to keep crime down or keep a system which profits off imprisonment afloat?
Thank you, Anya. Joining me today in Washington, D.C. is Edgar S. Khan. He is a law professor, former counsel and speechwriter to Robert F. Kennedy, and the creator of time banking, a currency that rewards decency, caring, and social justice. He is also the author of No More Throwaway People. He co-founded the Antioch School of Law with his late wife, Jean Camper Khan. The law school placed an emphasis on serving the poor and trained prospective lawyers in social activism. Let's talk about what has happened over your lifetime to the American legal system.
Well, I think the American legal system has been captured by the same focus on money and billable hours that we see pervading every domain, whether it's teachers and test scores, whether it's churches and mega buildings. So I see us as involved in what I call a Midas monoculture, where you live in a monoculture, and a monoculture is very profitable until it collapses. We saw savings and loan, and we saw how lawyers actually put together the loan instruments so people thought they were investing in secure investments because they were backed by a mortgage, but the mortgage was meaningless because the mortgages and the loans were given on the basis to people who could not pay back, and so that was going to collapse, but it was profitable for the industry. Lawyers put that together. In this book, No Contest, Ralph Nader talks about the ways in which mega giants in dealing with different kinds of health improvements, cataract operation and so forth, in effect stop competition and use the complexity of the law and used the ability really to wipe people out by extended discovery as a way of
explain extended discovery. What does that mean? Well,
that means you put people through depositions, but the depositions that they could threaten to would go nationwide and would have cost the creators of a new kind of cataract operation, a new kind of cataract replacement system, would have cost them well over $1 million. They couldn't take that kind of battering. So small enterprises, innovative enterprises that would have reduced the cost and reduced monopoly-related costs got knocked out. And this book is really an analysis and a description of that use of lawyering power. Now, I don't want to pretend that lawyers are necessary anymore, because particularly those who specialize in corporate law and corporate finance, any more than I would want to say that neurosurgeons aren't needed and you need a primary care doctor to go into your skull. I think there's a huge complexity about corporate law, particularly in the context of multinationals, but that doesn't mean that they don't have a responsibility as officers of the court to expand, literally you take an oath to expand the capacity of the legal system to advance justice and to address legitimate grievances of people so that the legal system can be doing what it's supposed to do, which is to effectuate rights and protect people from injury. Now, here I come down to what Congress has done to efforts to stop legal service attorneys from taking cases.
And we should say that you were the engine behind this program under the Johnson administration.
I and my late wife wrote the blueprint that said if you're going to have a war on poverty, you've got to have a vehicle to amplify the voices of poor people so you know what the hell they're going through. But second, you really need to find a way that system can be held accountable, and if the lawyers are going down a path that the clients don't want, you need to hold the lawyers accountable because they can go on crusades that are not appropriate. As a result of that, and I'm simply going to say that when I started, Lyndon Johnson had told Justice Arthur Goldberg that there was no way he was going to allow public money to be used to sue him. But when it came down to writing the regulations for the Office of Economic Opportunity, my job was to specify the kinds of services that poor people could get from community action programs.
That would be federally funded.
That would be federally funded. And somehow, not only did legal services get in there, but what shocked Sergeant Shriver was when we persuaded a Southern gentleman from Richmond named Lewis Powell, whom you may have heard of, that the American Bar Association supported it. Well, that blew everybody away, because this is originally, when we proposed this was called socialist law. This was government hiring lawyers, and obviously government money was going to somehow interfere with the independence of the profession and its ability to take stands because it could be bought off. Well, Lewis Powell decided that he wanted to advance justice, and he persuaded the entire American Bar Association. He did some manipulation, but he got the entire House of Representatives, House delegates to vote unanimously to endorse legal services, and so that put it on the map. Then when it came down to phasing out the war on poverty. Then my job and my wife's job was to write a memo for Chief Justice Berger, actually, as to what kind of an independent corporation could possibly be established that would protect the integrity and the independence of legal service lawyers. Well, then Congress comes along when it has to, because that's federally funded. It's probably the main source of funding for people who can't afford lawyers, but I have to say, I don't know a lawyer who can afford a lawyer, so that we've got a little problem of pricing, and a very important service to deal with all manner of problems. But when Congress then you'll see that Trump has asked that they zero fund the Legal Service Corporation, and that's a perennial battle that goes on. And in the past, the lawyers have championed, and the American Bar Association has championed refunding. So I really have to give them credit. What I don't give them credit for is the imposition of restrictions on every legal service attorney to do what any attorney for a rich person would do. Like, you can't talk to administrators about regulations. You can't lobby. You can't bring class actions. You can't handle a whole array of cases dealing with something called
there's a bill now to destroy class action, the ability to even carry out any class action lawsuit in the House. I think it's the House Judiciary Committee.
Well, I think it's time that we reminded the members of the House and the members of the Senate who are attorneys that then maybe they ought to be disbarred. Because if that's the price they want to exact, then they ought to pay a price for that. I think we have to, I think what we're seeing is that was true of gay rights, and now there happens to be a Supreme Court decision, so you can't, but you can, as a legal service attorney, deal with LGBT kinds of cases. You can't deal with something you may have heard of called school desegregation. You can't deal with domestic violence. So there are a whole array of situations which officers of the court, wearing their hats as elected representatives in Congress, have imposed those restrictions on legal service attorneys. Now, we know that legal service attorneys are really good at asserting rights, but they have to assert them person by person by person. When you're dealing with a whole public housing complex, when you're dealing with a whole neighborhood, and when you're dealing with what I call the school-to-prison pipeline that you may have heard of, where we've got schools in the district where 75% of the kids are suspended in the course of a year. So how much are they learning? You can't deal with the racial disparity because, frankly, what the statistics show is not the white kids who get suspended.
And we'll come back to that. When we return, we'll hear more from attorney Edgar Khan. With Chris Hedges. Welcome back to On Contact. We continue our conversation with Edgar Khan, attorney and author of No More Throwaway People. So at this point, how would you characterize the legal system? Is it a wholly owned subsidiary of the corporate state? Is it, we have seen appointments of judges who almost all, even under Obama, come out of corporate law firms. How would you assess the health of the judicial system?
Well, I think that we've got a product that is really critical to the freedom and pursuit of happiness and fundamental rights of people. But where I see the problem is, I don't know a public defender who can handle competently more than 150 felonies, walking around with a caseload of 500. Right. I don't know of any system that can do the kind of quality work that an individual public defender needs to do on behalf of a client with the kinds of caseloads that are being dumped on them because of the shortage of funding. So that's on the criminal side. So what they have to do, basically, because the prosecutors are then saying, we're going to go for the maximum. And now that the Attorney General has called for a revival of this broken war on drugs, We're going to see the prisons and the juvenile prisons, basically, flooded with kids for 10 and 20 years for having some marijuana. And they're not going to have counsel. They're going to be told, oh, just plead guilty and you'll go free.
There's no capacity within the courts to even hold trials.
So you've got a system that, in effect, says the only way you can retain even a semblance of freedom is to walk around with the rest of your life with a criminal record.
Right.
And that's called freedom, which means that you'll be barred from jobs, like things like teaching or hairdressing or other kinds of things, because you've got a criminal record. And then you've got to go through a whole process of expungement, but you can't pay a lawyer and you can't pay for the process of expungement. And the same lawyers who could help you with the process of expungement are usually barred by legal service requirements and restrictions put on them by this Congress, by officers of the court serving as congressmen and senators, are in effect tying their hands and saying, so how do I think the legal system is working? Is it wholly owned? I think that you have valiant people in the legal system who stand for the right things. I think the judges who knocked out those prohibitions on immigration and on were gutsy. I think Sally Yates stood up when she testified on behalf of the firing of the FBI director. I think she had guts. I think the profession, I'm very proud to be part of a profession where we stand up for what we do, but lawyers have this problem. They have to eat, and they have to have a roof over their heads. And so they have to deal with the caseload problems that the institutions that they're working in are saddled with. Legal service programs around the country are flooded. They serve close to 2 million, 1.8 million people a year. They turn away 1.8 million people a year, which means that we know that the level of injustices, the level of need to assert rights, which were established, frankly, in the 60s and 70s, and Russell McIver was part of that. You know, we had to deal back then with issues what were called privity and issues of faulty products and whether you could sue. You couldn't sue the manufacturer because you dealt with the dealer, and so there were all kinds of rules, and those rules changed. So you can now, there were all kinds of protections created by Congress which people can't use. So I would say we have rights that were established, but even more important, lawyers in legal service programs cannot really deal with another part of what is a fundamental part of the legal system. There are rights, and then there's something called powers. And powers are what you exercise to create a new right-duty relationship. When you form an organization like a nonprofit, you're exercising a power. When you enter into a contract or an agreement. And legal service lawyers basically are limited to the assertion of those rights that they're still permitted to assert, but they can't do the organizing. They can't help community groups really organize, because organizing of community groups is a specifically prohibited part of the funding that comes to legal service programs. The other source of funding for representation for poor people was the interest on trust accounts, called IOLTA funds. But as the percentage of interest plummeted with the banking industry, the money has dropped by more than 50%, and so the funding for services for poor people has gone down. I think this is a fundamental issue, and I think that Congress and the Senate and state legislators need to make sure that rights are effectuated. That doesn't mean they shouldn't assert rights for corporations to enter into agreements, but it does mean that they shouldn't use their knowledge of complexity to bar people, to bar lawyers who want to make sure that other rights that have been created can be asserted.
So the legal dilemma for the poor is analogous to what period of American history now? Certainly pre-60s,
there are more rights, but people don't know about them. There are more people coming out of law school and finding out that the jobs aren't there. And I think that, in effect, what people say is, we'll do what we can with what we have, but we close a blind eye to the extent to which effective assertion of rights would have made a difference. For instance, domestic violence went way down when lawyers were available to deal with that. Ironically, the offender who committed it, charged with an offense, has a right to counsel under Gideon. The person who was the victim of the violence does not. They have to go hire a lawyer.
Wow.
So you've got a perverse use of the right to counsel in those cases. But really, you know, we're talking about $150 an hour. We're talking for complex law, the price can be, for complex corporate and organizational law, it can be as much as $1,000 an hour or higher. And I don't know of anybody, I don't know of lawyers who can afford lawyers for their own personal use.
You were the dean with your wife of Antioch Law School. How do you look at the state of our law schools?
Well, as of last year, as a result of really pioneering work that we did in defining competency for graduate lawyers, every law school in the country now has to provide at least 6 units of clinical legal education for its students. Now, one semester doesn't really give you that competence, but it means they are at least exposed to something called building a relationship of trust with a client, talking to a client, beginning to formulate a hypothesis as to what rights might be available, maybe educating that client as to their rights. So I think, and really sensitizing, when I went to law school at Yale, we didn't even have professional responsibility as a required course. After Watergate, it became a required course. I think that the issue of, in no law school in the country, except the one that we started and that became the UDC David A. Clark School of Law, is system change itself a subject matter. Yeah. And we're talking about system change that is complex and that involves looking at, you know, no law is enforced without a system to enforce it. That means you've got to look at the personnel, their sanctions, what consequences arise when they try and assert a right or protect a right. And if you don't nurture the protection of those rights by the systems that enforce them, what are police going to do? What are prosecutors going to do? What are housing authorities going to do? What are welfare authorities going to do? If they just kick people off and people don't know their rights and don't have access to lawyers, then in effect you have once again a return to a lawless society.
And which is where we're going, and one of the ways that they put young lawyers in bondage is that they finish these schools owing tens of thousands, often over $100,000. And so how are they going to pay it back? Well, they have to go work for a corporate law firm.
Well, there used to be provision where if you stayed in public interest law for 10 years, if you could deal with that kind of debt, that your debt would be forgiven. We need more of that. We need the ability, by being all that you can as an officer of the court, advancing the ability of the system to do justice, we need to have loan forgiveness for people who will sacrifice an immediate return in order to really fulfill their mission. I think people come to law school because they want to make a difference, because they want to contribute. But I've got to tell you that the legal profession has the highest percentage of suicides of almost any profession. And that's because I think what lawyers are paid to do really takes them away from why they became a lawyer in the first place. And their sense that they're just on a treadmill generating billable hours, if necessarily even padding those hours in order to meet their quota. That's not the life that's not the career they wanted to go into. I think we need more lawyers who are dedicated to the principles that bring people to law school.
Great, thank you. That was attorney and author of No More Throwaway People, Edgar Khan. The 1 million lawyers in the United States, the deans of our law schools, and judges in our courts refuse to hold corporate power accountable to the law. They have failed us. They alone have the education and the skill to apply the law on behalf of the citizen. They alone know how to use the courts for justice rather than injustice. When this period of American history is written, the legal profession must bear much of the responsibility for our descent into corporate tyranny. Lawyers are supposed to be officers of the court. They are supposed to be the sentinels and guardians of the law. They are supposed to enlarge our access to justice, not narrow it. They are supposed to serve those who defend the law, not subvert it. This moral failure by the legal profession has obliterated our rights and taken from us our ability to protect ourselves from corporate abuse. Thank you for watching. You can find us on rt.com/oncontact. See you next week.